We're live.
Let's go on the record on cause number DC 208643, Mark Hume versus 5 Star Global. Counsel, make your appearances.
Good morning, Your Honor. Julie Pettit and David Urtiago on behalf of the plaintiffs.
Good morning, Your Honor. Cliff Riley with my colleagues Israel Silvis, Christopher Cradaville, and Maria McIntyre on behalf of defendants. Good morning.
Good morning, Your Honor. This is Sarah Kraske on behalf of defendant Southfield.
Okay, let's go ahead and proceed. I've read all the briefing on the motion for summary judgment. As I said earlier, I thought it was an excellent job by both sides. And so I get, whoa, what just happened here?
Oh, Your Honor, it was me. I'm sharing screen if that's okay.
That's okay. Yeah, go ahead and share screen. I guess we'll go ahead and get started.
Thank you, Your Honor. I hope you can see my screen okay.
Yeah.
I will be as pretty brief, Your Honor. I know you've read it, and I think it's a very narrow summary judgment that we're seeking, which is why my presentation will be so brief. So this is our motion for summary judgment on the $500,000 loan from the plaintiff.
Ms. Pettit, let me ask you a question before you jump into this, and this is, I probably want to get input from both sides, because it's not entirely clear to me something that was said on both sides, and maybe I missed a footnote or an attachment that will explain this, but there was an analysis done of this escrow account where this money came from.
Yes, Your Honor.
And there was, I guess, an audit done that said that had two different audits were done and with two different results as to what the source of that money was. I assume that escrow was something that both sides put money into, and I guess took money out of. I guess, why is there an uncertainty as to who owned the money in the escrow?
Yes, Your Honor. So the escrow money was put in as part of the proceeds that my client was supposed to receive as payment, essentially, for the assets that were transferred. It's a pretty common thing that this happens in a private equity transaction where they say, okay, well, there's some middle amount that might be in dispute of monies that one side still owes or the other side still owes. So we're going to put a portion or a chunk of money into an escrow account, and we'll sift that out later depending on who owes who any money at the end. So this was just an escrow account that was sitting there. This particular issue isn't before the court today, but there have been 2 audits of the escrow funds. We have another forthcoming summary judgment motion on the escrow issue. It's our position that the defendants waived any time to even make a dispute on the escrow account, but that's not before Your Honor today. So our position is they get no money from the escrow. Their position is they get the escrow money plus some. So that will be a hotly contested issue later before Your Honor, but for purposes of today, that's not before the court, but that's where the source of the money came from.
I mean, they've raised this issue, though. It is kind of before the court, isn't it?
Your Honor, that is absolutely an issue that will be before the court. At the end of the day, when the court says who's right and who's wrong, there may be some offset as far as who gets that money, but it is not relevant for purposes of our summary judgment motion today, and I'll explain that to Your Honor when I get into the presentation.
Okay. All right, go ahead.
Thank you, Your Honor. Okay, so as I mentioned, this is our motion for summary judgment on the $500,000 loan. I know you've heard about these parties a million times, so I'll be brief, but just want to make sure we're clear on who's who and who's asking for what. So my client are the plaintiffs, 5 Points Holdings LLC, which was formerly 5 Star Media and is owned by Mark Holm. There was an asset transaction where certain assets and intellectual properties were transferred to the now defendant, which is 5 Star Global, which is managed by a company called Defendant Capital. So those are the parties we're here about today. The roles of those parties are pretty important. So my client on the plaintiff side, my client's role was, of course, they're the ones that are contributing the assets to this new entity. And Mr. Holm was supposed to be the one that was going to be running the operation over at 5 Star Global. Obviously, he was fired. That's a whole nother issue for another day. But those were the initial roles. And Caledon's role was their name is Defendant Capital. Oddly enough, they had no capital, which is the problem, which kind of caused this whole thing to explode. So Caledon's role was supposed to provide capital for new ventures. When it came down to it, as we'll discuss later in the case, they didn't have capital to buy the assets to begin with, and they didn't have capital to buy AMAA, which is what this summary judgment motion is about. So Caledon's role was to acquire additional assets and properties for the new 5-star global entity. The first one that came to be purchased, or that was presented and liked by everyone, was an organization called AM&AA, and it stands for Alliance of Merger and Acquisition Advisors. So it's a big trade group of M&A folks, and so everyone collectively decided, hey, this is a good thing. We need to buy AMAA, and AMAA was for sale for $500,000. Everyone thought, this is right up our alley, we need to buy it. The problem was that Caledon, who has no capital, couldn't close on it. So my client over on the plaintiff side said, look, we think that we should do this. It's clear that you guys don't have the money, but we do. And we don't think anyone wants to pass on this opportunity. So we'll loan you some money so that we can buy AMAA. You just need to pay us back. Your Honor has read, so you know the summary judgment evidence of all of the emails, all of the drafts of the promissory note, all of the back and forth between the parties that this amount was going to be loaned from plaintiff's escrow account and then paid back within a year. Defendant's summary judgment evidence, I'll focus on that because I think it's really important to show that they're not disputing everything and that there is no fact issue on this limited issue regarding the $500,000. So first, they don't dispute that they didn't have the money. They don't dispute that my clients did have the money. They don't dispute that my clients funded AMAA. And so my clients send the $500,000 and the defendants now own this asset that my clients footed the bill for. And they don't dispute that it's never been paid back to the plaintiffs or put back in the escrow account. They don't dispute any of that. Briefly on our evidence, their own internal documents show that this was a loan from Mark Holm and that the money went. So here is their internal memo. It shows that this money was going to be pre-released escrow from Mark Holm in the amount of $500,000. If you look 11 months after, so my clients funded it January 31st, 2019. 11 months later, Southfield, who's the lender in this deal, even Southfield is acknowledging that this money is owed. Southfield says to my client, when you have a moment, email me your thoughts on how you're thinking about the terms of your note. I will personally make sure that matters get documented timely. So even their lender knows that. Further, if you look at defendants' own accounting records internally, so we have all their accounting records now through discovery. This is just one example. We put many examples in our summary judgment evidence, but their own records show that they made a loan, or that they have a loan proceeds from 5 Points Holdings, the plaintiff, right here on their accounts payable on their balance sheet. You can see that $500,000 is owed on this loan. They, I believe today, will wave around this email, which they are apparently pretty proud of, from my client saying, I'm perfect fine with spotting us the $500,000 to float this. So this is their big piece of evidence that I think they're going to focus on today. Even their own evidence, Your Honor, makes it clear that Mr. Holm is saying, we're going to spot you the money. If there's any doubt, now this is a first for me. I feel like I've done a lot of stuff, but this is a first for me. I'm actually going to quote and show you Urban Dictionary. He says, I'm fine with spotting us the 500,000. If we're not clear what spot me means, even Urban Dictionary says that means to lend, as in money or goods. So, Your Honor,
the first time I've seen anyone quote Urban Dictionary in here.
I figured, but
I do know what spot me means, but I appreciate you letting me know.
We will not object to it, Your Honor, to the definition.
So, Your Honor, this all comes down to one very, very simple question for the court today. All comes down to one simple thing, and it's this. Was the $500,000 a gift? Your Honor, all the defendants had to say was, plaintiffs gave us the money as a gift and we don't have to pay it back. If they had said that or put that in an affidavit or even tried to go that far, then summary judgment would have had to have been denied. But Your Honor, we know this wasn't a gift. If we go back to all of the things that I had on the screen a moment ago, there is no fact issue. The money came from my client. the money bought this asset. They've never paid it back. That's the only issue. Unless they're going to stand up today and cite to some evidence that I missed in their response, this wasn't a gift. Everybody knows the money was going to fund this, and the money was supposed to either go back to my client or the escrow account. I think today,
Let me ask you a question.
Yes.
And maybe you're going to get to this. I apologize, but what exactly are you asking for in this summary judgment?
thank you, Your Honor. I am getting there. It's in 2 slides.
Okay, sorry.
I'll be brief. I think what they're going to do today is similar to their response, which is a big sideshow. They're going to say, well, there's this working capital and there's this equipment that plaintiff used. And long story short, they're going to say that my client owes them all this money. All of that stuff is not issues before the court today. That's irrelevant. Those are all disputed. Those are issues for trial. If they're right on all of that, we disagree, obviously. But if they're right on all of that, then all of that can simply be offset. Well, what we are looking for, Your Honor, and I'm going to skip 2 slides. What we're looking for is a very, very narrow issue, which is they breached on the $500,000. Damages have to be decided later. There may be an offset. If it turns out that they're right on everything, then that's fine. And the point of this motion is to start narrowing the issues in a very complicated multi-party case. There is no issue that the $500,000 was given as a loan and that it has not been repaid. Whether that liability is eventually offset is for another day and does not prevent summary judgment today on this limited issue. What they have done here is essentially put the judge's hat on and given themselves a pre-judgment writ of garnishment, saying, yeah, we know we didn't pay it back, but we think at the end of the day, you're going to owe us money, so we still get to keep it. They've nominated themselves judge, I guess, and taken this money. We're just looking, as I said, for a very narrow summary judgment finding just as to liability.
Can you explain, I guess, this quote from Pegasus Transport, why this is relevant? Because I'm not sure if I get this.
Sure. So we're not asking the court to find damages or to find out who comes out ahead on some sort of offset issue. We think all of that will happen later. So this is a narrow, an amount less than the full amount sought. We agree that down the road, the court may find more in our favor or more in their favor. We're just seeking a narrower finding that there was a breach as to liability on a limited issue of a $500,000 loan that was not repaid. That's all we're asking for.
And that's one of the causes of action you have in this case is breach of contract for this $500,000. Okay, that's what I was trying to get at. Okay.
Sorry. So again, it comes down to this very, very, very simple question, which was the $500,000 a gift? If not, then summary judgment should be granted. We can argue about the offsets. We can argue about working capital. We can argue about all that stuff, and I'm sure we will down the road. But that's why we're looking to narrow the issues with a very, very simple finding for this summary judgment motion. Thank you, Your Honor.
Okay. Response?
Good morning, Your Honor. I'm also going to share the screen for a PowerPoint if that's acceptable.
Okay.
Okay.
I'm glad you asked, unlike Ms. Pettit.
Sorry, Your Honor.
It's okay. I'm just kidding.
I'm going to make sure I get this right. Ms. Pettit is faster at doing it than me. I can say that. Okay.
Ms. McIntyre, do you want to help him or do you have it pulled up?
I think I have it, Your Honor. It's taking up the whole screen. I might apologize.
It's not showing on the screen, at least my screen.
That's not okay here. Okay, can everybody see it now?
Nope. Can you see it, Ms. McIntyre?
No.
Here, I'll move this over here. This one.
Okay.
My apologies, Your Honor. All right, let's see here.
You don't have to have a PowerPoint if you don't need one. It's not working.
Yeah, I think it is. This is strictly human error right now.
All right, looks like it may be working.
Okay, you see it now? You see my screen, Your Honor? And everybody else? Okay.
Yes.
All right, here we go. Okay, this will be the simplest way. I think we can make it work. Okay. Your Honor, good morning. Cliff Riley on behalf of defendants. Your Honor, plaintiff's motion, traditional motion for a partial summary judgment, must be denied, we believe, for two core reasons. First, Your Honor, plaintiffs cannot conclusively establish an enforceable oral loan agreement existed. This is the relief they seek before the court today. I believe they cannot prove it. Second, Your Honor, there are numerous fact disputes that necessarily preclude summary judgment. Your Honor, turning to the first issue, plaintiffs cannot conclusively establish an enforceable oral loan agreement because one, it is missing essential terms, and two, plaintiffs did not own the escrow funds that form the basis of the alleged loan. Now, Your Honor, very briefly, the court is familiar, the elements of a binding contract: offer, acceptance, and strict compliance with the terms of the offer, a meeting of the minds, each party's consent to the terms, and execution and delivery of the contract with the intent that it be mutual and binding. Your Honor, for the contract to be enforceable, it must include all essential material terms, or it is not enforceable. And Your Honor, in Texas, it is well settled that for a loan agreement, there are four essential terms. One is the amount to be loaned. The second is the maturity date. The third is the interest rate. And the fourth are the repayment terms. Now, Your Honor, we believe each and every one of these essential terms is either missing or it is fully within dispute right now. And I'm going to turn to what I believe is the most important, Your Honor, and that is the interest rate. Now, the seminal case on this matter, which both plaintiffs and defendants have cited to this case.
Ms. Pettit, are you seeking interest on this?
No, Your Honor, that's clear from our motion. This is just on the $500,000.
Okay.
Your Honor, I don't believe that's correct. I believe that both plaintiffs have pled for interest rate and they're seeking interest as part of the loan.
Are you seeking interest as part of the loan, Ms. Pettit?
Your Honor, I think our motion is clear. It's our position that interest could have been due, but on this particular $500,000.
Because wasn't there discussing it maybe 1.9 and then maybe there's different.
And that was not our position in the summary judgment motion. We're only moving on the $500,000 loan. That is
So let me ask you this. Are you reserving, do you anticipate that you would argue at trial or at some future date what the interest rate is, or are you waiving interest?
We're waiving on the interest in regard to the $500,000 loan. Now, if the court finds prejudgment or post-judgment interest, then that's separate.
Of course, that's
But
definitely
as to the $500,000 loan, we're only moving on the $500,000. That's what we are asking for.
with no claim of interest.
Correct, Your Honor.
Okay.
Does
that resolve your issue, Mr. Riley?
It does not, absolutely not, Your Honor, because what we're dealing, first of all, I would say that's the first I've heard of that. In fact, if you look at not even the traditional motion for summary judgment, I just pulled up plaintiff's reply brief on page 7. They on the last box in this chart, they say the loan was not interest free, which I think is kind of a roundabout way of saying it was an interest bearing loan. And Your Honors, I will get to shortly. In their live pleading, the 6th amended petition, they specifically alleged that the loan agreement that was allegedly entered into between the parties, there was a meeting of mind between the parties, included an interest rate. So we believe, Your Honor, that first of all, they are seeking their pleas an interest rate, but regardless, that's not impactful of the analysis. That when we try to learn whether there was a meeting of the minds, whether interest rate was a term that was agreed to, whether they waive it now or not, that doesn't matter for the analysis. All it does is perhaps create a new fact dispute, but we don't believe a waiver they're saying now makes any difference in the analysis. Your Honor, so the seminal case that both parties have cited to in their briefing is the T.O. Stanley Boot Company v. Bank of El Paso case. In this case, Your Honor, the Texas Supreme Court held that no binding contract existed, where there was no interest rate provided for the alleged loan agreement. Your Honor, in reaching this decision, the Texas Supreme Court relied upon the case of Bridewell v. Pritchett, and this case backed up the Supreme Court's holding. In that case, the court held there was no meeting of the minds as to an alleged oral loan agreement where the interest rate was not agreed to, as the interest rate is a material term that the
So
court
did those
cannot-
cases find if the interest rate is not agreed to, then the loan doesn't have to be repaid?
Your Honor, there's no enforceable loan agreement if there was no interest rate agreed to.
Okay. So the money did not have to be repaid, even if the money was already paid.
Your Honor, well, in our case, we contend additionally, and I'll get to this after the interest rate, that the money does not belong to plaintiffs. We believe it's a fatal defect also, that this was an escrow account that both parties had contingent rights to. We believe that the defendant had a superior right, but we would agree that both parties had contingent rights. But this, we would at minimum dispute that plaintiffs owned.
Are you going to use this PowerPoint or not? Because it's a little distracting if you're not using it.
Oh, I'm sorry, Your Honor, can you not see it?
I can see it, but you're not using it at all. It's just a bunch of, have you been switching screens or are you just
Oh, no,
the front page?
I'm sorry, Your Honor, it hasn't been switching?
No.
Oh, it's just been on the very first page?
Yeah.
Oh my God.
Unless other people, has it switched, Mr. Artiago, is it switched on your screen or is it still the front page?
I have not seen any of the pages go by, just see the front screen.
Okay, maybe this will go better.
Is this, can you see it now, Your Honor?
I can see it. I could see it before, but it wasn't switching screens. Okay, now it is.
Okay, my apologies. I went over these and it was switching on mine, but you could not see it. Let me catch us up to where we are. This is the seminal case, Your Honor, the T.O. Stanley Group case. And I just went over the Bridewell v. Pritchard. And here, this is the quote from the Bridewell v. Pritchard case upon which the Supreme Court relied. And it held there had been no meeting of the minds as to the alleged oral loan agreement where interest rate was not agreed to, as the interest rate is a material term the court cannot supply. Now, Your Honor, it's just black letter Texas law that if there's no interest rate as part of an oral loan agreement, even a written loan agreement, then it is not an enforceable agreement because the court cannot supply the interest rate. Now, to get around this black letter Texas law, plaintiffs cite two unpublished cases that purport to provide an exception to this ironclad rule. The first case, Your Honor, is Jackson v. Carlson. This is the case plaintiffs rely upon. However, this case and the other they rely upon are factually distinguishable because of a key reason, a key fact that's not an issue here. And that is, in the Jackson v. Carlson case, the court did hold a loan agreement was enforceable despite not having an interest rate. The reason that was the case is because the plaintiff did not seek interest. They did not allege that the parties ever agreed to an interest rate as part of the loan. They argued that it was a non-interest bearing loan. Because there was no interest alleged to be part of the loan from its inception, the court held, well, it's not a material term if the parties never alleged an interest rate, it was an interest bearing loan. The court quoted, Carlson is not asking for $5,000 plus interest.
I don't find this argument about interest very persuasive as long as, now I would agree with you if they were trying to argue that, hey, the interest rate is 18% and you should supply that even though that's not something in dispute. But if they're alleging here today that they're not seeking interest on this other than prejudgment, post-judgment interest, then I would agree. I think that would be the law. So let's go to your next argument because we're going to run out of time. You have 33 slides and you're on slide 8.
Sorry, sure thing. I'll explain.
So let's skip ahead to your next argument.
Okay, Your Honor. I will just say that the interest rate we think is important for the next argument, which is there was never a meeting of the minds. This is not academic, Your Honor. The negotiations over the alleged loan agreement broke down. The summary judgment evidence shows that they did not actually come to an agreement. First, Your Honor, this is an email that's in plaintiff's motion for partial summary judgment that they've offered. And they show that defendant's attorney stated, I believe the interest rate will still be a sticking point as the current interest rate is 1.9% currently. I think we're waiting to see if Mark, Mr. Holm, is agreeable to that interest rate since 7% doesn't work for my client. They were making it clear that they had not had a meeting of the minds. Your Honor, the declaration of John Harrison attached to plaintiff's motion discusses the 6% interest rate and said, this was the last draft of the promissory note I received. They had not signed a promissory note. The declaration of Mark Holm, Your Honor, stated that they had not explicitly agreed to the specific interest terms of the note. They had not had a meeting of the minds. Your Honor, turning to another exhibit from plaintiff's motion for partial summary judgment, A4. This is an email from Mr. Baggett of 5-Star Global. And in the email, which plaintiffs rely on this email quite a bit, but I think it's important for the meeting of the minds argument. Mr. Baggett claims, quote, "For what it's worth, I think the last round had 6% interest instead of 7%, so we may need to chat, the three of us, and go back to Doug." What he's saying here, Your Honor, is on February 4th, which is 4 days after the closing of the deal, they had still not come to an agreement on the alleged oral loan. And then finally, Your Honor, again, this is on plaintiff's motion. This is their evidence. This is an email from Mr. Doug McCullough, the attorney for plaintiffs, who negotiated the deal. And he's saying to 5-Star Global's attorney, "I just spoke with my clients, and it seems our clients have reached, quote, an impasse." Your Honor, I don't know if there's a better one single word to demonstrate that there was not an agreement, that there was not a meeting of the minds. They could not agree as to the terms of the agreement. They've reached an impasse. So Mr. McCullough says, at this
Mr.
time—
Pettit, let me ask you a question, both sides, I guess, and that's, so if, I'm wondering if this is really a breach of contract case, because if there's an impasse, you know, your client gave $500,000. I mean, is this more appropriate for some kind of equitable release, money hadn't received or something, as opposed to a breach of an oral? You know what I'm saying? I agree your client needs to be—
I'm sorry, I was a little bit distracted because of Mr. Silva's dancing in front of the camera when Your Honor started to talk. So I'm sorry, I was a little bit distracted, but I think there's absolutely a breach of contract case. There may also be equitable arguments, but we're not moving on anything like money hadn't received or anything like that today. We think that there is sufficient summary judgment evidence that this was not a gift. All Mr. Riley and Mr. Silvas had to say was that this was money that we were given with no expectation of ever paying it back. And they can't say that. We all know they can't say that. So whether or not we have other claims.
Okay, so let's give this as an example, I guess. Why I kind of wonder about that is, let's say that Ms. Pettit, you were going to loan money to John Smith, and you offered to loan money to John Smith, and then you just give him, you know, $500,000, and John Smith says you don't reach an agreement as to interest rate, anything like that. Is there really a contract there? He's accepted the money. There might be a money hadn't received claim against them. Hey, you should get the money back. But my question is, should you be able to get attorney's fees when these issues have not been worked out? And
yes,
I guess maybe it's distinguishable from what we have today, but I kind of wonder if this is more of a money hadn't received, or, you know, something like that, as opposed to—
If I may respond, Your Honor. So I am in agreement that there is at least a fact issue if I was moving on an interest rate today, but we're not. There is no question. They're internal documents. Everything says it's a loan. All of the documents say loan. The reason why there is an impasse on this one exhibit is just in regard to the interest rate. The Pegasus case that I had on the screen makes it clear that we don't have to move on everything that we might have had a right to. We're allowed to move on less than could have been owed. And that's all we're doing for here. There definitely are all of the elements of a contract here. There are loan agreements being circulated. There are loans on their books. Their lender is saying this is a loan. Everybody knows it's a loan. We're not moving on the interest rate. Pegasus allows us to do so, and we're looking for just a limited finding on breach. It may also be the elements of another claim, but that's not before the court today.
Okay. All right. Go ahead, Mr. Riley.
Okay, Your Honor, I just briefly respond that it doesn't appear to me that the Pegasus analysis has any impact on the essential terms required for an oral loan agreement. We don't believe that you can cut in and cut out some. The interest rate is obviously critical, but we believe that to have a meeting of the minds, that's the analysis. And the parties' communication showed that they had reached an impasse, that they had not come to an agreement. And Your Honor, we think this email is also important because it shows, well, how are they thinking about the deal? He says, well, this time it would be better to either return the funds or issue a 60-day note, which would be a new sort of agreement, because they never signed a note. They never signed an agreement. They were negotiating, certainly. But if we're here on a breach of contract claim, Your Honor, and for breach of contract, there quite obviously was no meeting of the minds whatsoever. Your Honor, to be quick, we believe that issue is dispositive. However, in addition, plaintiffs cannot establish that Mr. Holm or 5 Point Holdings owned the escrow funds. Your Honor, both parties had contingent rights to the escrow funds. We've cited and provided the asset purchase agreement, which is the APA, and it clearly states that to the extent the buyer is entitled to losses, then they can take those from the escrow account. And Your Honor, this was not just a contract provision. This was hotly disputed by the parties. As we've stated, there are 2 separate audits that were undertaken because this had been so disputed as to who owned the funds and in what amount. Riveron, an accounting firm, concluded that 5 Star Global was actually owed almost the entire amount, $426,459. Whitley Penn, in a separate audit, concluded that 5 Star Global was entitled to over $326,000. This was a hotly disputed issue between the parties. And today, in fact, Your Honor, it remains in dispute because there are now claims in this lawsuit over the amount, who is owed what amount. This amount, this contested amount, Your Honor, is exactly what was the loan. This was the basis of the loan. Neither party owned it. Plaintiffs cannot claim they had an absolute right to the funds, and defendants cannot, except defendants do believe they have a superior claim because the APA makes clear that the Whitley Penn audit is the final, binding, and conclusive report for the parties on the issue. So we believe that at minimum, 5 Star Global had a superior claim. At the very least, there's a fact dispute as to who owned the loan and in what amounts. Your Honor, another important piece of information is that this loan was executed through a joint release. Mr. Holm, the plaintiffs say multiple times in their pleadings that Mr. Holm or plaintiffs wired the money. That's incorrect. It's at minimum disputed. The escrow agent wired the money only after receiving a joint release. This is the joint written instructions to the escrow agreement, which is Exhibit C to defendant's response. And as you'll see, Your Honor, it has signatures from both Mr. Holm and from Mr. Baggett of 5 Star Global. The only way the escrow agent was going to release the money is if both parties released it. This was not Mr. Holm's money. He had no right to do it on his own, in fact. Both parties had to, and both parties wanted to use the money. Your Honor, I'll move briefly to what I think is also an important point. This is a draft memorandum sent by Caledon Capital to Southfield, and plaintiffs rely on this quite a bit, but I think this is also very important. Here, the memo states that there will be a $500,000 pre-release escrow from Mark Holm, creating a company liability on the same terms as the escrow per the transaction APA. 5 Star Global was clear. This is obviously not part of an agreement. This is a communication to Southfield, but they've always been clear to say that the funds were still subject to their rights of offset under the APA. And it had always been marked as a liability because the default is for the funds to go to Mr. Holm. But they had long ago contested that the conditions were satisfied and they should not have gone to him. They had asserted their rights, and the 2 auditing reports showed that they were justified in their disputes. Your Honor, we believe that even plaintiff's reply shows that the parties had to sort out their difference over the ownership of the funds. They stated themselves, the ownership of the funds was at issue. And this is important for 2 reasons, Your Honor. One, an essential term of a loan agreement is the amount of the loan. Well, we have one issue, which is who owned the funds. I think that the evidence makes clear that neither party had absolute ownership. They both had contingent rights. We believe 5 Star Global had superior claim, but at minimum, it was disputed who owned the funds. Second issue, Your Honor, is the amount of the loan. What was the total amount of the loan when the offsets were taken into place? Well, they had been fighting over this for a long time, and plaintiffs admit it had been disputed. So, Your Honor, we believe that this evidence shows the parties had reached an impasse. There was no agreement. But in addition, we believe summary judgment is not appropriate at this stage because the trier of fact has to determine a number of issues. One is, what was the interest rate? Was there an interest rate? 2, who owned the disputed escrow funds? 3, what was the total loan amount? And then 4, was there a meeting of the minds? We believe a few of these answers are clear, but at minimum, these are trier of fact issues. Now I'm going to speed through these, Your Honor. We included this in our briefing. We're not going to belabor the point here with the court because the court has indulged our time, but we have provided in our briefing many other contested facts where the evidence on the record just directly contradicts the plaintiff's statement, showing there are disputes of fact. So I'll move to the very end here, Your Honor. Conclusion. This email we do rely upon. It shows Mr. Holm on the day before the closing of the deal. He says to Mr. Baggett, Mr. Lay, I will send this, which is the joint escrow release. Both parties signed. I just showed you earlier. So I will send this escrow release to Jake to stamp my name and forward it. If this does not release in time, I'm perfectly says perfectly fine with spotting, which we don't contest the Urban Dictionary definition of spotting as lending, with lending us the $500K to float this. We would not even need to paper that if it's needed. Your Honor, this shows Mr. Holm was contemplating two alternatives. If the joint release went through, then that was fine. The parties' mutual money was going to fund the deal everyone wanted. If that wasn't going to get released in time, in that scenario, he was fine with lending $500,000 personally. He even shows that there was an alternative method to make the deal happen. And plaintiffs numerous times in their briefings say that Mr. Holm demanded to document the loan. But here, that's contradicted by the statement, we would not even need to paper that if it's needed. Your Honor, for those reasons, we believe that as a matter of law, the parties did not reach an agreement. There can, on a breach of contract claim, there can be no enforceable agreement found. And in addition, there are numerous disputes of fact that we think necessarily preclude summary judgment. Thank you, Your Honor.
All right, brief response.
Yes, I'll be very brief. Your Honor, the essential terms were that we give them $500,000 and they give it back. That's it. Those are the essential terms. Everyone agrees that that happened. And for those reasons, and under the Pegasus case, we believe that the court should grant summary judgment.
Let me ask this real quick, because I want to make sure I kind of understand it. It says that, was the money released from the escrow account, or was the money spotted by Mr. Hume?
It was released from the escrow account. Mr. Holmes said that if for some reason they couldn't get the release done, he'd spot the money. But it was
But he didn't actually spot the money.
Correct. Well, he did through his escrow account, but it didn't come out of his pocket that day. It came from his escrow account.
Was that, but the money that was put in the escrow account, was it just from him or from other folks as well?
It was to go to him. The APA, or excuse me, the escrow account was in plaintiff's name to go to plaintiff, subject to any offsets that the other side might dispute later on were owed. So I agree. If later on Your Honor finds, you know what, Mr. Holmes shouldn't have received the $500,000, then that can be offset down the road. There's no question Your Honor has that ability if you later find that that escrow money wasn't due to him. But the agreement was the money either needs to go back to the plaintiffs or be put back in the escrow account. Caledon and the defendants have done either.
Your Honor, if I may, there's a protocol established in the escrow agreement, and that would not have been possible because they had disputed the amount. Mr. Holm could not have just taken the money once a dispute had arisen and the audits had been performed. At that point, the money would not have just gone to him. Only a joint release would have allowed those funds to go because FSG, Five Star Global, was entitled, if they got the determination they ultimately did, that they were entitled to some portion of those funds. And they filed their dispute and they had a contingent right to those funds.
I keep ready to ask, Ms. Krajewski, do you have a position on this?
We did not submit papers on this, and we don't have a position. Okay.
I do think this is a really close call. I'm kind of struggling with two issues. One is this really a money hadn't received as opposed to a breach of contract? I can see the argument on both sides. And then secondly, I want to look more deeply into the escrow. When is your trial setting on this case?
I believe it's in November, Your Honor.
I believe that's right.
Okay. And is there any deadlines that I need to get this ruled on by? Is there like discovery that is contingent on my ruling here?
I don't believe so, Your Honor. I will say that we are still working through document review and we have depositions. We think those could impact the analysis. We think that summary judgment separately is premature for that reason because no depositions have taken place in this case, and perhaps it would be better suited for a time after depositions have been taken.
Well, Your Honor, there was no motion for continuance that was filed, and certainly we think that the evidence before the court is more than sufficient to show they received this money and refused to give it back.
I'm just trying to figure out when I need to rule by. That's my main issue, not how I rule, but I'll try to get a ruling sometime in May on this. And then the next summary judgment hearing, was that canceled or is that still on for May? I think it's May 17th.
Your Honor, the next summary judgment that was set was by the null parties, and I'm glad to inform the court that the parties have reached a resolution of that matter. So I believe that will come down. We're just waiting for it to be funded.
All right, let me just, that was set on May 14th.
Yes, Your Honor. So it was originally set sooner, and after we signed the settlement agreement, the parties agreed to push that back pending the funding of the settlement
Okay,
agreement.
yeah, that's the same thing. Okay, I was just trying to, when is our next, so that we don't have any pending hearings in this case, right?
There is
don't
nothing
believe so.
pending, Your Honor. So I think as Mr. Riley indicated, the next step, as the court may recall, there's actually a companion case, which is the Delgado matter. We're about to take depositions in the case at the end of the month. And then we're also finishing up our review of documents recently produced by Mr. Holm. And we do anticipate beginning depositions in May. So I would agree with Mr. Riley that it does seem to be premature to have a ruling at this point on the motion for summary judgment as it stands today, without the benefit of having additional testimony that might shed light on many of these issues.
There wasn't a motion for continuance filed, so I'm going to rule on what I have. So
That is correct, Your Honor.
why don't we do this, Ms. Pettit? Why don't you prepare a proposed order reflecting that you're seeking breach of contract without interest? And then Mr. Riley, why don't you prepare an order and submit it denying the summary judgment? And I'll go ahead and review that and get you an order sometime in May.
Will do, Your Honor. Thank you.
You could
Thank you.
email those both to Rhonda. All right, guys, good job, both sides. And we'll see you for the interns and staff. It looks like our 1:30 hearing got canceled, so our next hearing's at 2:30. Okay?